arbitral clause, right? Second one, if they signed under that, it means if they say in the agreement, if they say they need to go to arbitration agreement regarding this, that is arbitral agreement. If in the agreement, if you found any clause has arbitration, they need to go to arbitration. Also, the separate arbitral agreement also there to resolve the matters regarding that matter. So here the first instance says they having a arbitral agreement, right? They having an arbitral agreement. Now the dispute has begun between the parties, right? Dispute has begun between the party. So now, guess will they go to court or arbitration? Before they're having an arbitral agreement, if there any dispute occurred, they need to go to the arbitration center. The agreement says like that. The second the dispute happened between the party, then they will go to court or arbitration center. Definitely, it is the arbitration center. They will go to arbitration because the agreement they have. This is the first instance. So second instance, now we are going to second instance. Here, there's no preliminary arbitral agreement. There's no arbitral agreement before, right? There's no initially arbitral agreement. Here, within two parties, the dispute began. Can be any party, right? The dispute began. Now they mutually come into the contract, or they decided to go to the arbitration, not to the court, right? Now, before the second instance, there's no arbitral agreement between the parties, but the dispute began and they mutually consent or created a decision to go to the arbitration center and not go to the court. Definitely now also they can go to the arbitration, not to the court, right? They mutually consent, no, they can go to the arbitration. Now the third instance. In the third instance, as much there's no arbitral agreement, the dispute began. Here the change is only one party has a consent to go to the arbitration, not the other party. Only one party giving the suggestion to go to arbitration or likely to go to arbitration, not the other party like to go to arbitration. They are suggesting another another dispute resolution method, right? So what will happen? Now the parties cannot go to the arbitration. They can only go to the court. The court will resolve their matter, not to the arbitration, because there's no mutual consent, right? That is the thing, the judication. Now the fourth one, actually the last part of our video. Here, how the proceeding of the arbitration. What will happen? What will occur in an arbitration? So, first one, summon of the party, right? Parties will summon to the arbitration center, or else if it's an ad hoc arbitration, they will go to the place which they choiced, summon of the parties. Second one, presenting the dispute. They should present the dispute to the arbitrators. Then only the arbitrators acknowledge what is the dispute is, right? Presenting the dispute form by written or orally can they give. They can tell orally what is the dispute, or they can explain within the written form also. Next one, the two parties can make argument, right? Like the formal litigation or like the formal courtroom, the both parties can make arguments. Now you will ask, make arguments mean do any other party represent the disputants? No. Disputants can make the argument directly to the arbitrators in front of the arbitrators, right? This is a positive thing, right? They can explain what is the real problem, how they're facing it, what is their thought or intention without explaining by another one, right? Another person. So they can make argument directly in front of the arbitrators. Right? Summoning witnesses. As the courtroom, they can summon witnesses also. Summoning witnesses, they are what? The authoritative by the High Court. Right? Someone authoritative by the High Court. Before also we studied or we learned that the High Court has interfered in arbitration in Section 80 on removal arbitrators. Here also summoning witnesses. Actually, what happened? If one of the party has witness from outside and they are refused to present to the arbitration regarding the dispute, High Court can give a warning letter or mandate letter, request letter by the High Court to present to the arbitration. It compulsory. Yeah, the court will send a letter to the party witness to present to the arbitration on particular day. So if High Court send the letter, the witnesses should present to the arbitration on the particular day. They can't refuse it. So the High Court somewhat authoritating making powerful the arbitration. Next one, presenting the evidence. Like the courtroom, they can present the evidence to the arbitrators to more scrutiny the disputes. Then I said the parties directly can make their arguments regarding the disputes. If they like, they also can appoint attorney at law regarding their side. Also, the attorney at law also can represent the parties in arbitration. That is a plus point. And if a normal party do an argument, if attorney at law do the argument, that is positive for the parties to explain the matters much more legally, right? So literally, they can explain much more. Actually, there's a restriction in the arbitration act. Actually, in Sri Lanka, if there's any disputes go to the arbitration, they can appoint attorney at laws. Only Sri Lankan attorney at laws can appoint, not the attorney at laws from outside. But that is not the same to all the countries around the world. Only for Sri Lanka, the arbitrators will grant the decision. That decision, particularly court has awards. They can grant awards to the party. The award should accept by the both parties. They can't say if there two parties are there. So one of the party can't refuse to accept the award which granted by the arbitrators. Like the courtroom, the both parties should accept the award. Right? Then after granting the award, this award will send to the High Court by the arbitrator. It will send to the High Court. High Court will enforce it. High Court will enforce it. After 14 days of granting awards, but before 1 year, it will enforce that decision. Right? Then it is same like, not same like, the decision will be same as the court decision. Right? So it will enforce the award, the particular decision after the 14 days and before 1 year. If one of the parties or both parties can be there. One of the parties or both parties dissatisfied with the decision of the arbitrators regarding the disputes, they can appeal to the Supreme Court, right? They can appeal to the Supreme Court within 60 days. Within 60 days after granting the award, they getting the award, they can, if they are dissatisfied, they can appeal the decision to the Supreme Court. These reasonable facts. If not, it will dismiss the appeal. This is the basic idea of the arbitration, right? So we just discuss what is the advantages and the disadvantages of arbitration. Actually, advantages, you can say it is less time consuming, reasonable time only allocated, reasonable time, right? It is quickly we can get the decisions. It is somewhat likely to quote formality, and parties are freedom to choose the place of the arbitration which is comfortable to them. Also, that is a positive thing, and they can provide evidence, witnesses, make the argument directly, not has the courtroom by the attorney at law, definitely by explaining the dispute to another party, another person, and that person can explain the matter to the court, not the party which directly connected to the dispute. Here, not like that. In arbitration, parties can directly argue. That is the plus point. Mm, chance to appeal to the Supreme Court, and also for the court system, it is a way to reduce the flood of the cases on court. More confidential in land matters, it will go to the district court, and we can appeal to the high court, and it will go to the court of appeal. Also, we can appeal, or then we can go to the Supreme Court, right? We can appeal. We have many choices, many steps to appeal. But here we have only one appeal chance, only to the Supreme Court. If the Supreme Court decision is unsatisfactory, we can't look into the another appeal. That is the decision should be accepted by the both parties without any refusal. That is the disadvantage on arbitration, or the dispute will be protected, not as the formal court. So this is about the arbitration, and today the video, so this is about the arbitration. So we'll meet with the another topic on another day. Thank you.